So now we're moving on to Pamela Zevitt. Pamela is an RP Bio and the SCCP Special Products Coordinator. She has her own consulting business and is also the Vice President Chair of the Practice Advisory and Professional Ethics for the Association of Professional Biology. Among other things, she has also been working on a decision support tool for private landowners to protect critical habitat with the Pacific water shrew as the initial species for piloting, which she'll be introducing now. Normally she's facilitating this with me, but today she's acting as a presenter. So I'm doing it all.
That's great.
So Pamela, you're there. You can take it away.
Great. Thanks very much, Christine, and good morning, everyone. Yeah, it's not typically that the onus is turned on me to actually have to basically entertain the crowd for a half an hour. So I do want to talk about the project that I have been working on. It's definitely complementary and relevant to Adrian's presentation, as well as a lot of the work that we have been doing here on the South Coast around species at risk, critical habitat, local governments, and private land. And just to follow up on a comment you made, Adrian, about sort of the populist vote when it comes to species at risk, I do have to say that the Pacific water shrew unfortunately has not found its niche as a charismatic, popular species with landowners. It kind of falls in that same place as many of the smaller, more cryptic creatures like the tail dropper slug. And a lot of people tend to think that they're actually rodents. So they don't necessarily get kind of the good rap that they need when it comes to conservation efforts. Now, in respect to dealing with critical habitat protection, I'm actually going to do a bit of backtracking because I think it's important to look at this broad context of Species at Risk Act. And the reason I tend to harp on this quite a bit is because whether it's dealing with local governments, politicians, developers, private landowners, and even within my own community of practice with qualified environmental professionals, there's a constant need to remind individuals about what the Species at Risk Act is all about, and more importantly, what is this private land context for critical habitat and species at risk. So this is just a brief overview, this slide on sort of the approach that the federal government takes. Remember, SARA is federal legislation. Monitoring, assessment, response, recovery, and evaluation. These are all ongoing processes, and they're all about improving a species status and protecting the habitat that it requires for its survival. Now, there's been a lot of work that's been done to date since SARA was implemented. You can see on that little lazy Susan that this graphic represents that there has been a number of sort of assessment and status reports that have been happening on a more holistic scale. So looking at the state of wild species in Canada, that was in 2010. The state of Canada's birds came out in 2012, and that actually includes a section on the Pacific region. And all of these documents are available on Environment Canada and Climate Change, their website, as well as Biodiversity Canada. And I do urge people to actually take a look at it because it provides some really important sort of trend information to provide context. The other thing that we need to remember is that there's this whole recovery planning process that's going on. So there's a number of resources that are out there around implementing the Species at Risk Act for different sectors. What does it mean? More specifically for the context of this conversation, for Pacific water shrew, the recovery strategy was finalized in 2014. And it is basically a feedback system. So even though we're kind of working at this point to implement recovery strategies, and we are seeing a lot more recovery strategies coming out now, so there is a lot more pressure happening. Definitely since fall 2015, they have been getting pumped out a lot faster. We're also doing the implementation, and all of that feeds back into constant need for monitoring and evaluation, and then the whole system is starting up over again. So I'm going to spend a little bit of time talking about this issue of critical habitat and effective protection, again, because I tend to hear a lot of different information circulating out there. Now, I want to provide a little bit of a caveat. I am not a lawyer. We had Janice Walton from Blake's on our first webinar to provide much more of a legal context around SARA and how that is actually rolling out in British Columbia. But I'm going to give a little bit more context setting based on the information that is actually readily available on the federal government website around the Species at Risk Act. So when we're talking about critical habitat, this is a habitat that's necessary for their survival or recovery of a listed wildlife species, so that's federally listed under the Species at Risk Act, and that is identified as the species critical habitat in a recovery strategy or in an action plan for the species. So thinking back to that recovery strategy from 2014 for the Pacific water shrew, the critical habitat that's defined and identified in that recovery strategy. And under Section 58 of the Species at Risk Act, automatic protection is afforded to critical habitat on federal lands, which most people I tend to think realize. So those are lands that are owned for the use of various federal government departments. So if you think about Canadian Wildlife Service on Westham Island, the Coast Guard stations like the one at Kitsilano, the Department of National Defence lands like those in Chilliwack or Vancouver, federal prisons, and First Nations reserves. Those are all things where there is this automatic protection mechanism for critical habitat. But it's also important to remember that SARA applies to all lands in Canada. So the big question mark and what the focus is for the South Coast Conservation Program in many instances is that critical habitat on non-federal lands, or what we tend to think about as private land, although that can certainly fall into the issue of Crown land at the provincial level as well. So under Section 61 of SARA, it's expected that landowners and land managers, including those that oversee provincial, regional, municipal, and private land, will apply approaches that effectively protect critical habitat. And subsection 61(1) of SARA says that no person shall destroy any part of the critical habitat of a listed, endangered, or threatened terrestrial species. So that's an important thing because people tend to lump all species at risk together. This is talking about threatened and endangered species, not special concern. Special concern species do not get critical habitat identified in a recovery strategy. All they get are management plans. So that effective protection mechanism is looked upon as measures and mechanisms that can reasonably be expected to protect that critical habitat from alteration. And this is kind of a legalese way of defining it, that would be reasonably expected to reduce the critical habitat's capacity to provide for the recovery and survival of a species at risk. So one of the things that Christine mentioned is that I also wear a hat within my professional group with biology professionals, and that issue of reasonableness is always coming up when it comes to how the court views specific issues. Now, for private land, SARA sets a 6-month window for protection of critical habitat, and that is for aquatic species. And remember, after it's been identified in a finalized SARA recovery strategy or action plan. For the non-aquatic species, so thinking about species like the Pacific water shrew, a variety of approaches to address critical habitat are provided under the Act. SARA contains a prohibition against destroying any part of critical habitat, but also provides other options for protection. And critical habitat species needs to be protected typically through the following mechanisms. This is the application of a SARA prohibition order or ministerial order. Sometimes these are known as protection orders, and more commonly people have referred to it in the past as a safety net order. You can also have conservation agreements. This is something that's quite relevant to the work that the South Coast Conservation Program does as well. Conservation agreements are sort of collaborative agreements that happen between the land use interest and the federal government around protecting critical habitat. And there is a proposed policy for critical habitat on private lands that was open for consultation, and actually the consultation, as far as I know, closed on March 31st. Now, what happens around the destruction of critical habitat? Well, SARA Section 58(1) speaks to the fact that no person shall destroy any part of the critical habitat of any listed endangered species or of any listed threatened species, or of any listed extirpated species if a recovery strategy has recommended the reintroduction of the species into the wild in Canada. So just for context, we have a number of extirpated species in British Columbia. Those recovery strategies are actually posted. They tend to get done very quickly. So as an example, the Puget Oregonian, the gopher snake. We also have a number of species that are extirpated on the south coast of British Columbia, but they're found elsewhere in the province. Okay, so what about exceptions to this rule? Well, there are some activities that can be considered damaging or destructive to critical habitat or impact a species at risk, but they can't be approved by the federal government if specific conditions are met. So there are permits or agreements that can be authorized for such activities. They're usually reviewed and assessed on a case-by-case basis. These authorizations are sometimes called Section 73 permits, and they refer to the section of the Act that deals with these authorizations. Now, when it comes to determining whether critical habitat is effectively protected, the federal government uses a four-step process called Critical Habitat Protection Assessment, and the acronym for that is called CHPA, C-H-P-A. So the big question that often gets asked is what happens if the gaps cannot be filled and effective protection is not achieved? Well, on non-federal lands, SARA requires the Minister of the Environment to recommend to the Governor and Council that a protection order, again referred to sometimes as a safety net order, be made to protect critical habitat that remains unprotected. The Minister of Environment and Climate Change Canada must recommend that the order be made if the Minister is of the opinion that the laws of the province do not effectively protect the species or the residences of its individuals. Now, the intent of the protection order is to provide sort of an ultimate federal regulatory protection to species at risk and their residences. And remember, that's if the species at risk is a non-aquatic species or not a migratory bird. And again, with the exception of species of special concern. The minister can defer the order. However, if there's sufficient and reasonable steps being demonstrated to ensure that effective protection is actually being put into place. So say there is movement towards issuing a particular ministerial order to invoke protection of a species under SARA or its critical habitat, and the provincial government or the parties that are the focus of that particular order move to mitigate or to address the circumstances that are generating the order in the first place. So again, I want to recap. If it's not federal land, and we're not dealing with migratory birds or aquatic species, there is really no protection of critical habitat without a federal ministerial order. And to date, only 2 such orders have been issued under the Species at Risk Act. And the most recent one was in Quebec, which is of relevance to the work of organizations like the South Coast Conservation Program, because it involved the province, a municipality, and a private land development. And right now, there are issues cropping up around a petition to the federal government for mountain caribou, which can involve issues around how the provincial government is protecting critical habitat for that particular species. All right, so that was a very, very long-winded recap on Species at Risk Act and critical habitat. But again, one of the reasons why I tend to like to go over this information is because I hear a lot of different interpretations of things going on. And all of this information is readily available on the federal government website when it comes to talking about the interpretation of SARA in the various sections. So let's take a look at a little bit of the federal to provincial context, like what is trickling down here to generate the activities of an organization like the SCCP around critical habitat protection. Well, there is this accord for the protection of species at risk, and it confirms the commitment of the federal, provincial, and territorial ministers responsible for wildlife towards a national approach for protecting species at risk. BC and the federal government have an agreement regarding the roles in the management of species at risk. And this was done in 2005 through a Canada-British Columbia agreement on species at risk. And British Columbia actually became the first province or territory to negotiate and sign a species at risk bilateral agreement. And the purpose of the bilateral agreement was to clarify the respective roles and responsibilities of BC and Canada related to species at risk. It was also designed to coordinate efforts between the two levels of government. It's things such as information sharing and consultation, and establishing joint priorities. And what's interesting to note is that one of the out clauses in the bilateral agreement says that this agreement will terminate 10 years after the date of its execution. The parties will review the effectiveness of this agreement 5 years from the date of its execution. Now, I haven't really been privy to a lot of the discussions that have happened around the bilateral agreement. So given that the bilateral agreement was signed in 2005, it's now 2017, I actually haven't heard anything. And if anybody actually does know, as to whether or not the agreement was re-signed and if there's been any changes around that. So I'd be really curious about it. Now, when we look at sort of the legacy around how species have been protected in British Columbia, it's important to note that there were some things that were happening behind the scenes around provincial legislation. And again, this is really relevant to the issue of dealing with critical habitat protection and species at risk on private land in British Columbia. So the slide that I'm showing here is actually just taking a look at some of the stats. It's already become a little bit out of date because I haven't been able to keep up with the number of recovery strategies that are getting issued, and there have been action plans as well as management plans that have been issued even within the last couple of months. But even before that bilateral agreement was signed in 2005, BC was actually looking to act on Species at Risk Act responsibilities. And in May 2004, the BC legislature enacted several amendments to the Wildlife Act to enhance the ability of the government to designate, manage, and protect species that are at risk in British Columbia. It was known as Bill 51, the Wildlife Amendment Act, and that came out in 2004, and I think a lot of people may have forgotten about that. And the 2004 amendments provide Cabinet with the authority to list any species or population of animal, bird, fish, plant, or other species, such as species at risk, to ensure additional protection. Now, what the province was looking at is what is typically referred to, and I think more people are familiar with, the red and blue listed species. And those are ones that are found on the Conservation Data Center website. I think a lot of people tend to get confused between species that are federally listed under the Species at Risk Act and red and blue listed species. And it's important to distinguish those two things because being red or blue listed in British Columbia does not necessarily mean that it's afforded protection or that its habitat is afforded protection. One of the enacted amendments, Section 6 of the Wildlife Act, does empower the provincial cabinet to designate a species as endangered if, as a result of the action of humans, it is threatened with imminent extinction throughout a significant portion of its range, or to designate a species as threatened if it's likely to become endangered. Now, since 2004, so since that amendment process was actually happening, 4 species were legally designated as endangered or threatened in BC, and that's the Vancouver Island marmot, the American white pelican, the sea otter, and burrowing owl. So those 4 cute, charismatic species that are seen at the bottom of the slide. Now, the clincher here is that a regulation was and is needed to bring these amendments into force. And the regulation will include a list of species at risk that will be protected under the amended Wildlife Act, as well as the option to designate a species residence. So here's where the critical habitat link comes in. So example, that would be an individual burrow, den, nest, or roost for a species at risk. Now, that regulation has not been developed to date, and so the intent of the Wildlife Amendment Act has never really truly come into force. And because of that, we're still in this quandary about the issue of whether or not BC has effective regulations in place to protect species at risk. And the same question I'll be asking at the end of this presentation. Okay, so what is this all leading up to? Well, the South Coast Conservation Program has a focus on species at risk conservation for the South Coast, or the lower southwest corner of British Columbia. And we have, since our inception in 2005, been very focused on working with private landowners, but also working with local governments, because part of Adrian's presentation really gave a good backgrounder on the role of local governments in dealing with protecting sensitive ecosystems and providing the types of resources and tools that they are able to under provincial legislation to protect those areas. So understanding the species at risk landscape here in British Columbia, what are some of the key learning outcomes that have contributed to the South Coast Conservation Program wanting to move forward with developing tools for conservation and stewardship on private land? Well, looking at those two program streams around private landowners and working with local governments, we've had a number of learning outcomes to date. Our work with local governments specifically indicated to us, and this is what local governments have been telling us, is that their needs vary greatly from local government to local government. There's often a lot of sort of divergent issues between how staff and politicians see species at risk responsibilities. Local governments tend to feel they need more tools to deal with public and developers. And they themselves also need a better understanding of the legislation and how and where it applies. And if we look at what landowners are telling us, is it follows a very similar pathway. The landowners and developers, well, they are that public that the local government refers to. And that public sometimes also includes elected officials, because we have instances where elected officials may have property that has critical habitat on it or issues of conservation value. So they are that body that local governments are dealing with, and they too feel that they need to have more adequate resources when it comes to understanding and dealing with species at risk issues. One of the things that we have learned is that species at risk responsibilities and how they are to be dealt with is not trickling down to private landowners in an effective way. There's a lot of very divergent and sort of disparate views out there and a lot of information that gets circulated. And we also need to understand better what landowners are dealing with and the ongoing issues they're having in understanding and navigating critical habitat and species at risk issues when they actually do become aware that their property has been affected by these things. So that has moved us towards this approach of wanting to add another tool to the toolbox. Adrian mentioned things like the Green Bylaws Toolkit. I'm actually going to have a slide in just a bit that shows some of the resources that have come out of that around species at risk. So this past year, we received funding from the federal government under the Habitat Stewardship Program for Species at Risk to begin developing a critical habitat protection decision tool. And it's focused on the South Coast. And as Christine had mentioned, our pilot species is the Pacific water shrew. And the tool is being developed based on the biophysical characteristics found on properties that are within designated critical habitat. And the initial test application in regards to municipalities we're working with are the cities of Surrey and Coquitlam. We've also been discussing opportunities to collaborate with Squamish, as Pacific water shrew critical habitat has generated significant issues for a development proposal there. And specifically, I'm talking about the Thunderbird Creek, Garibaldi Highlands area. What we're trying to do is ensure that basically the human-made threats to critical habitat are getting reduced. And what we want to ensure is that this tool can be expanded for use with other SARA-listed species whose critical habitat has been identified. So what we're working at right now is we're just sort of finishing up the latter part of year one, and that's to develop the first draft decision support tool for the Pacific water shrew. And I'm going to be showing you sort of the draft of that and what it looks like. So I've actually worked on version 3 of the document now as of the end of March. That's been done up. But because things are in draft, I can't actually circulate it. And we still want to work with refining that tool with local government partners as well as some landowners who have stepped forward to help us with it. Now in year 2, which is basically this coming year, we'll be refining the tool. Again, working to beta test it a little more effectively on the ground. It's really great to devise these things in a conceptual way, but we actually don't know if they're going to work appropriately or what their usability is until we actually start working with the people that are affected by these issues. So as an example, I live in Coquitlam, and I've approached a councillor here to consider being a bit of a test case for it, because they have property which has a riparian area on it, which could actually be used as kind of a test case for dealing with critical habitat for Pacific water shrew. Now, one of the things that's noted in the slide here is this issue of taking a front counter approach. This is a very broad application when it comes to a resource tool. Even though the South Coast Conservation Program does deal with private landowners, most of the landowners that we're dealing with are individuals who are already taking very proactive steps or are really interested in doing conservation action on their property. We want to have a resource that is going to be readily available for the average person, whether it's a single family home owner that is looking to do a redevelopment or some activity on their property that may lead to the disturbance or may impact critical habitat. Most of these property owners are not going to even know that they have critical habitat on their property, or that they fall within a particular distance from critical habitat for species like Pacific water shrew. So coming into that local government environment where they're going into the permitting area, whether it's to get a building permit or a development permit, soil conservation permit, tree bylaw, all of those things can help trigger providing more of an effective communication mechanism to get this information out to those audiences. The benefit, though, is that having at the local government front counter also means that the local governments themselves have to have a greater awareness about the content of that tool, because we want landowners to have more active discussions with their local governments about these issues. So that there is more of a consistent understanding. All right, and just a little bit of a sideline, a little bit of a cheer for the Pacific water shrew. One of the reasons that it was chosen as sort of our pilot species, and there certainly are a number of other species that we do see expanding this tool for. It is the only federally designated, and it's designated endangered species of water shrew in Canada. It has, as its northern extent of its range, southwest British Columbia. So it's only found in southwest BC in all of Canada. And this species of shrew is what's called an aquatic specialist. Its habitat preferences include things like streams and wetlands, forests and riparian areas. And these habitats are by and large the most common focus of land use and development issues that have arisen around species at risk on BC's coast. So it's a good candidate, sort of forms that umbrella species approach, because it encompasses so many different types of habitat areas where its critical habitat has been defined. So it is an ideal and useful model for landowners and local governments to work through their SARA and critical habitat responsibilities. And I should note that we don't have a lot of really good active sort of in the wild shots of Pacific water shrew doing their thing. They're the smallest warm-blooded diving animal, smallest warm-blooded diving mammal. And we often tend to have more pictures of their closely related cousin, the American water shrew, which is what I've got here on the slide. It's important, though, that when we're tackling these types of processes, as with all of the resources that the SCCP develops, we do not want to reinvent the wheel. So part of my work has been looking at where similar types of decision tools and guides have been developed for developers and landowners and municipalities in other jurisdictions. Now, one thing I didn't mention when I was talking about that federal BC context around SARA is BC does not have standalone species at risk legislation. We are kind of a little bit of a loner when it comes to that in Canada. So one of the things that I've been doing is reviewing through other provinces that do have specific legislation around species at risk, the resources that they have. So Nova Scotia is one of the ones that I have been looking at. They have a number of really good documents available online. And then also Ontario, which has significant resources around species at risk conservation and fairly up-to-date resources as well. Now, Adrian mentioned the Green Bylaws Toolkit. There are some resources in the new revisions to the Green Bylaws Toolkit that look at sort of opportunities around species at risk and development permitting and bylaw processes that a municipality can undertake. And you see that on the left-hand side of that slide. That's the flowchart that you'll see in the Green Bylaws Toolkit. On the right-hand side is one from Nova Scotia. So we want to build on the resources that are out there, but we also recognize that they may not be that well designed for the general public to easily understand. We want to find what's called a Goldilocks tool or develop a Goldilocks tool. And that's one that is going to provide sufficient background information, but it isn't so utilitarian and bureaucratic that the average landowner is going to just be dazed and confused by looking at it. And even more concerning is where they get really frustrated by being given specific tools and lack the understanding or the background or the guidance on how to apply it or understand it. The federal government actually has developed some, reasonably good resources for landowners. And in an ideal world, what happens is that landowners who are affected by defined critical habitat and recovery strategy receive notification documents about being affected. But we've become aware over time that landowners don't seem to recollect getting that notification. Now, remember, the recovery strategy for the Pacific Water Shrew has been out there since 2014. There are a number of critical habitat polygons in that recovery strategy. Some of them fall on municipal land or areas that are already protected, but some of them affect private lands. And so there is definitely a disconnect between that notification and recognition that an individual landowner is affected by critical habitat and what the intent of bodies like the federal government have been to actually do effective consultation around that. And the other problem that we have is that the federal government comes up with a lot of these really great tools, but they also disappear very quickly. So as an example, when you look at the ones on this slide, the one on the left-hand side is still available on the federal government website, and they have two. They have one for private landowners and one for developers, but it's not like something you would actually find quite easily. The one on the right is actually the more recent one, but it's not available publicly anymore. We still have it on the SCCP's website, but that one is no longer available publicly through federal government. We're not sure why, but again, their information tends to change quite frequently, which makes it a lot harder for landowners to find the resources that they need and get the questions answered. So one of the more recent documents that we have developed, it's a very sort of like Cole's Notes version, just to hand out to landowners or make available to landowners, and something that local governments can download and print, is this nifty little brochure that Christine has developed for us. And again, it's a very quick and dirty sort of summary while we're developing this more extensive decision support tool for critical habitat. It's downloadable now off of our website. If you go to our website, sccp.ca, and hover over the Resources tab, you'll see a drop-down for local governments, and when you click on that, you'll be able to download this brochure to take a look at. Okay, so getting back to the project at hand, this is an example of the step one within our existing critical habitat decision support tool. So it's important to note that this is just kind of a standalone graphic where we've tried to encapsulate all the potential steps that a landowner may need to deal with if they're affected by critical habitat, and specifically for Pacific Water Shrew. But as part of this document, there is, again, that SARA 101 backgrounder. There's explanations on how to find critical habitat mapping, because we want them to actually go and find out. As I mentioned, they don't necessarily get the notification around being affected by critical habitat and recovery strategies. And then also steps around harm reduction. So what are the types of things that a landowner can do to try to reduce potential threats and impacts to critical habitat? One of the things that Adrian had alluded to is this issue around having qualified environmental professionals. In most cases, it usually ends up being a biologist, but there may be other QEPs, which is the acronym, that may have appropriate skill sets and be accredited within other professions like forestry or agrology. But we wanted to provide a checklist for landowners to have so that they can make informed choices about retaining QEPs when that becomes a necessity. And more often than not, it will have to be part of this picture. They should be asking questions to make sure that the individual that they're retaining is appropriately skilled and qualified to be undertaking work around species at risk, because not all biology professionals are created equal when it comes to their understanding around the legislation, being able to adequately identify habitat attributes, and being able to advise their clients in a way that's consistent. But we also want to provide a bit of a checklist for landowners around some of the mitigative things that they can do to reduce harm. So we're still fleshing all of that out. The other thing that we have to think about is there a reasonableness factor around guiding landowners on protecting critical habitat? Do they need to be taking the same steps if they want to build a small tool shed versus put up a 5,000 square foot home? These are the sorts of things that we need to refine as part of this process. And I should point out that at the top left-hand corner, it talks about taking it step by step, and then it says the activity of proposed development is within 100 meters of the critical habitat. So we were looking at sort of what those trigger buffers should be. 100 meters has been something that's been discussed by Environment and Climate Change Canada around being sort of a trigger for initiating, undertaking activities and actions around critical habitat. So we're using that because there's a bit of a precautionary approach. Pacific water shrew are species that have fairly large buffer requirements from their core habitat areas. They're known to utilize riparian areas within 100 meters from water courses and water bodies. So we wanted to actually use a particular buffer that was going to be a little more of an umbrella approach. But there's also these situations where a landowner may go through the steps of actually trying to find their property, whether it's working with the local government if they have effective sensitive ecosystem or environmentally sensitive area mapping, or if their local government has actually created a data layer available around critical habitat that's found within their municipality. There's going to be situations where they come up empty. Now that doesn't mean that there isn't critical habitat for Pacific water shrew on their property or near their property. The problem is that it has not been identified in a recovery strategy. It could be as Canada habitat listing that hasn't made it to an update yet, or perhaps there is critical habitat for other species at risk and they've only been focused on looking for Pacific water shrew. Or there's potentially habitat that's important for other species of conservation concern or other species that are protected but not listed as species at risk. So we wanted to actually create sort of this secondary tier of direction for landowners to take so that things were not falling through the gaps. We tend to get very focused on one particular area of guidance and then we forget about all the rest. So this again is our first sort of take at developing this sort of quick and dirty decision support tool. And again, it's surrounded by a lot of background information that we want to be able to provide the landowner, but in a way that's usable and understandable and isn't going to be too daunting or scary. There's a number of issues that we still need to address to make this effective protection tool effective. We have to harken back to what landowners and local governments have been telling us. There's definitely an ongoing issue about whether or not this means that development can't occur. SARA doesn't actually, unless there's a protection order issued that actually halts a particular activity, SARA doesn't provide that sort of black and white guidance around whether or not something can or cannot happen. Elected officials have raised the issue about, well, what about compensation? And for those that have been involved in the past on things like the riparian area regulation, the sensitive ecosystems inventory, way back when, for those that might remember the streamside protection regulation, these issues have always cropped up. When it comes to the need for a private property owner to actually undertake something that may reduce their ability to do an activity on their land, what does that mean for them? Are there mechanisms in place to help to alleviate that particular burden? We also see this as an important mechanism to sort of bolster this activity around conservation agreements and stewardship agreements with private property owners. Again, there's also this sort of disconnect. What happens if we're sending landowners to talk to their local governments around species at risk because we want both of those parties to have a consistent discussion and understanding, but the local governments can't actually provide them with the information, or they can't actually get a hold of the provincial or federal representatives that they need to talk to get the actual regulatory advice. And that actually touches on the last bullet that I have there. We need to make sure that when the SCCP is providing guidance on these issues, that we're very clear that we're not a regulatory authority. We're not providing legal advice. And how do we ensure that we're not giving the impression that if you do this particular activity, you're going to be okay and you will have effectively protected critical habitat, because that's not something that we can actually advise landowners in an explicit way. So at the beginning, I talked about the issue of the reactionary methods that SARA is being employed right now. And I talked about the fact that of these emergency orders or protection orders that are issued, there's only been 2 to date under SARA. And these are tied into the fact that the failure by a body to actually ensure that critical habitat is effectively protected on non-federal lands can lead to an order by the governor and council to basically force them to do their due diligence and their responsibility around critical habitat protection. And again, that is known sometimes as the safety net order. So the 2 that have happened, the one that was for sage grouse in Saskatchewan happened a few years back, and that actually had implications for the oil and gas industry as opposed to private landowners in Saskatchewan. The most recent one, which happened this past summer in 2016, is the one that really set some important precedent, because it did actually halt the development on private land of in a particular community within Quebec. But the point that I want to make is that this is a very reactionary way of dealing with conservation. And species at risk create a lot of concern, and they create a lot of contention, and the SCCP is trying to reduce those conflicts. We don't want to be embroiled in constantly having to deal with whether or not we're going to have to keep forcing and relying on the federal government to initiate protection orders on a species by species and site by site basis. That is not an effective way and a long-term way to actually protect species at risk. When we think about the Pacific water shrew, as I discussed, it has critical habitat that's identified and defined within a recovery strategy. But you cannot easily answer that that critical habitat is effectively protected wherever it occurs. Certainly where it overlaps with an existing protected area, such as a municipal provincial park, there's likely more protection happening there for that critical habitat. If that critical habitat overlaps with a migratory bird or a fish species that's listed, yes, there's probably more of a holistic protection happening there for that critical habitat. But we also need to remember that, it's 2017 now, and that those Wildlife Amendment Act provisions have never actually come into force, and we still do not have standalone species at risk regulations and legislation in British Columbia. So we don't want to we don't want to have that wait and see approach as an organization. It's not effective for the long-term conservation goals that we are mandated to work on. And we recognize that there's a lot of opportunities for collaborative partnerships, knowledge, and cost sharing. So we see this as sort of the road to recovery and effective critical habitat protection that we're trying to build on with landowners and local governments on the South Coast. And we're hoping that when this tool is actually finalized and we can get to a point where there's more broader consultation on it, that it is going to be sort of the useful sort of key stepping stone while we wait to see what happens sort of at the higher level with decision makers. And that's it. Thank you.
Great, thanks Pamela for sharing the development of this tool, and hopefully we can gain more feedback on it. I'll open up the floor for questions. We have some initial questions for Adrian. So Environment Canada and Fisheries and Oceans have critical habitat data. Has Saanich or anyone thought about using this data in creation of DPAs or other local government work? If so, how?
That's an interesting question. In terms of fisheries and oceans, I imagine that their data would be offshore, and at the moment we haven't extended our development permit areas offshore, but we do have the ability to go a certain distance out. And no, we haven't really looked at the critical habitat data. We're aware that it's there, but it's another possibility. It takes quite a bit of manipulation, though, and time to incorporate this kind of data into a development permit area. So it's not something that we've considered taking on yet.
Okay, great, thanks. There's another question for you. Who does the enforcement if there's no compliance? If people are doing work with the DP, who follows up to make sure they're doing the work according to the DP? I guess anyone can answer, but.
Well, in Saanich, if a complaint comes in, it's normally someone from Environmental Services, and we have the option of also asking a bylaw enforcement officer to come with us, and also to have a parks arborist come with it if it's a tree issue. And we also have our legal department to assist us if we need to go that route, but normally the route we go is to try to get compliance through replanting, revegetation, that kind of thing.
Okay, great, thanks. So another question regarding the CDC. Are they still lagging behind on data by 1 to 2 years or more?
I think that'd be a question for the CDC.
Yeah. It's interesting presenting on the CDC behalf. On their behalf, but yeah.
They are definitely starting to get a little more up to date on certain taxa groups. If you sort of use their BC Species and Ecosystems Explorer regularly and look at their webpage, there have been a number of updates that have been happening. There's also been more species that are getting added. And I just know from communications with staff there that they are, yes, finally getting to deal with some stuff that I had submitted quite some time ago. But they do seem to be putting a little more effort into bringing things up to date. They certainly recognize that this has been a long-standing issue.
Okay. Guess it's a lot of data. This question as well, I'm not sure if any of us should be the ones answering it, but why are there inconsistencies in distribution records between IMAP and those shown on the BC Ecosystems Explorer and eFauna? if you add the appropriate layers, IMAP seems to provide the most details. However, several points are missing if you look at the maps offered through the Ecosystems Explorer with your eFauna example, coastal tailed frogs. Shouldn't everyone be coordinated to be more streamlined? Yes, that would make it easier.
Yes. I think that's a question you have to ask the folks at UBC in regards to eFauna and eFlora. And then also, yeah, a question for the CDC.
There's another question here. What is the local government's responsibility to protect species at risk for red and blue listed species if critical habitat is not identified? If we wanted to, how could we do that? Through other bylaws?
Yeah, the red and blue species, I don't think there is a firm requirement there. I know there's a bit of debate about that. So the best way I feel is through development permit areas, because then the areas are identified, and even if there isn't critical habitat identified, at least if you know the location of a species, you can include that in your development permit area. The problem is when you discover a species that hadn't been previously mapped and now you have development on your doorstep. That's more difficult to deal with.
Right, yeah. That's often when everything's in reactive mode. And certainly some of the situations that have triggered the development of the decision support tool are based on the fact that we've had these conflicts that have been arising quite recently, but also it's been a long-standing issue. It's important to note, though, I mentioned about sort of the hesitation of using red and blue listing as sort of a mechanism, and I know that a lot of the stewardship groups that we deal with, they often use red and blue listing when they're talking about protecting species at risk. We tend to be focused on using language around what SARA identifies as threatened and endangered and special concern, because there is more of a regulatory certainty around that, as much as I've just said that, you know, there is uncertainty as to whether or not critical habitat is protected. And blue listed species are special concerns. So remember that they do not get critical habitat identified for them, even at the federal level.
Okay, there's a final question. How have the recovery strategies for species at risk incorporated protection from climate change?
Pamela?
So I'm assuming that the person who's asked the question actually has been reading some of the recovery strategies. I cannot explicitly say that all of the recovery strategies talk about climate change. When you look at the threats section for each specific species, and remember, threatened and endangered species get recovery strategies, there are potentially issues that allude to climate change effects, whether it's changes in habitat values over time, or the fact that a species' habitat can be affected by things like sea level rise. But I would have to go back and read the plethora of recovery strategies out there to know whether or not climate change is explicitly listed. But I would be surprised if it wasn't, you know, either alluded to or spoken to explicitly in some recovery strategies for some species.
Yeah, that's great. Thank you. And thank you both. I think that that's the end of the questions, and we're right on schedule somehow. So I would just like to thank, oh wait, there's one more. I'll ask one more question. This for Adrian. How long did it take you to refine down the CDC data for Saanich to use?
Well, as I mentioned, it's a real team approach between a biologist and a GIS specialist. So there's a lot of backing and forthing that goes on, and creating methods for the GIS folks to actually take what you want and put it into something that makes sense for them so that they can manage it over time. I would say it probably would take at least 4 months of backing and forthing to do this. Once you have it done, though, keep maintaining it is much easier because everyone has a really good understanding of the data and what you want to use and what you don't want to use and how to manipulate it. So it does get easier over time.
And to update it for revising. Okay,
yeah.
That's great. Okay, well, I'd like to thank you both for sharing your experiences in developing these tools for species at risk and all the lessons you've learned. And thanks for your continued efforts for species at risk. We'd also like to thank the Habitat Stewardship Program for providing the funding for this webinar. We'll be posting the webinar to the SCCP website once I process it. And thank you for joining us to explore and discuss species at risk critical habitat tools. Please get in touch with me at conservationplanner@sccp.ca if you have any further questions or seek to work with us to increase protection of species and ecosystems at risk. Our next webinar will be scheduled for either late summer or the autumn. And that's all, folks. Thanks for listening.
Thank you.
Thanks very much for organizing, Christine.